There are four key changes. And so the first change is, I guess, tidying up this issue around who's a contractor and who's an employee. The second change is around dismissing employees who earn over 200k. Employment laws in New Zealand had become a little bit employee friendly, and they wanted to pull some of that back. They've done what they said they were going to do, and they've done it pretty quickly. So, well, look, we can't just rely on all these process issues. I think there is going to have to be a bit more of a focus now on what Joe Bloggs actually did.
Tēnā koutou katoa. Haere mai o nō mai hoki mai. Welcome back to the What a Lawyer podcast. This is a show where senior practitioners from across Aotearoa share their stories, skills, and legislative insights, designed for emerging lawyers and curious minds looking to learn from those who have been there and done it. I'm your host, Sam Lindsay, an agency director at Chisholm Clark, where I help lawyers navigate their careers both in New Zealand and internationally. And through this podcast, bring you real conversations that you can learn from and apply. Joining us today is Fiona McMillan, a partner at Lane Neave, specialising in employment law and health and safety. She holds a Bachelor of Laws and Political Science from the University of Canterbury, began her career in Lane Neave's Christchurch employment team under Andrew Shaw. Early in her career, she gained broad exposure across employment, health and safety, family and criminal matters. With the exception of a short period at Langdon Hudson Butcher and a fixed-term role at Perpetual Guardian, she progressed through the ranks at Lane Neave from solicitor to partner, including building and leading the establishment of their firm's Auckland office. Fiona advises on the full spectrum of employment issues, including performance management, misconduct and serious misconduct, medical incapacity, restructures and redundancies, collective bargaining, human rights commission matters, and independent workplace investigations. She has been widely recognised in the industry, including a nomination for Young Lawyer of the Year at the New Zealand Law Awards, and consistent rankings in Doyle's Guide, the Legal 500 Asia Pacific, and the Chambers and Partners. She was also named one of New Zealand Lawyers' elite women in 2022 and 2023. Outside of her legal practice, Fiona enjoys travelling, spending time with her family in Christchurch, and she is here today to discuss the recent employment law changes and guide us on what they actually mean for us. What a Lawyer, it's Fiona McMillan.
Good morning, Sam. Thank you for having me.
Oh, thanks very much for being on the show again, Fee. We really appreciate your time. Let's start. What have you been up to lately?
Well, I guess this current government, from a legal practice perspective, has been keeping me pretty busy with all of these changes. I guess we always knew a lot of these changes were going to come into play, but they all end up kind of getting rolled out pretty quickly towards the end of February of this year. So from a work perspective, I've been trying to get my head around these. From a personal perspective, I'm not long back from a weekend hanging with my nephews and nieces in Christchurch. So I've definitely come back to work for a break.
Cool. So refreshed and ready to go with a huge workload. Classic,
Absolutely.
right? Yeah.
Absolutely.
All right. Well, look, thanks again for taking the time out to sit down and discuss what these changes are, what they mean, so that our audience can generally gather some pretty good nuggets from you, okay? Let's learn a little bit more about the background to this recent change, the reform, the update. Do you think you could talk us through these key areas? And I'll give them to you one by one so that we can get some really good detail per question. But before these changes came in, do you mind describing to us what was happening beforehand?
Well, I guess probably as we go through each change, we'll probably touch on the previous position and then now the new position. But I guess by way of background to that, when this current government came in, Brooke Van Velden, the Workplace Relations Minister, was very clear that they were of the view that employment laws in New Zealand had become a little bit employee friendly, and they wanted to pull some of that back. So I think no matter what your view is about the current government, there's no doubt that they've they've done what they said they were going to do, and they've done it pretty quickly. So I guess probably the main stuff we're going to talk about are the most recent changes to the Employment Relations Act and the Employment Relations Amendment Act. But there's also some stuff to come as well that probably would be quite useful to touch on, just so people can keep an eye out for it.
Yep. Absolutely. So as a whole, what is this recent change or this recent update? What is it actually trying to solve?
Yeah. So I guess there are 4 key changes. And so the first change is, I guess, tidying up this issue around who's a contractor and who's an employee. The second change is around dismissing employees who earn over 200K. So the argument is that actually they have the means, that they're well within their rights to negotiate their own terms. Employers shouldn't have to put up with personal grievances from employees who earn it at that level. And then there's this 30-day rule around individual employment agreements, collective agreements, which we'll probably dig into a little bit as well. And just probably the last big change under this legislation is around what employees at the Employment Relations Authority can actually be awarded if they go all the way to the authority, but it actually turns out that they were a little bit of a rascal in the workplace and they contributed to that in some shape or form. So those are probably the 4 big changes under the legislation.
Cool. And we'll get into those one by one as we get through, just to give you some more chance to give us some detail there. But so per change, let's start with the first one. You've got key provisions. Do you want to go with contractor versus employee first?
Yeah, go for it.
Cool. So what are the key provisions of this change?
Yeah. So I guess pre this change, if there was a dispute as to whether or not someone was an employee or a contractor and it all ended up in the Employment Relations Authority or employment court, the court would be required to look at, well, what was essentially the real nature of the relationship. And when they did that, they looked at a number of factors, such as what the intention of the parties was when they entered into the relationship, what the economic reality was, etc. I guess as a result of that, we ended up with some pretty strange case law, in my view, on this issue. And I know I found it really challenging, both when an employer and an individual would come to me and say, look, is X a contractor or employee? Often my responses was, well, look, my view is X, but if we get to the Employment Relations Authority or court, I just can't be as definitive. And then I guess to add to that, many people listening to this would have followed the Uber case as it went through the courts. And that resulted in a finding that those particular Uber drivers were employees, not contractors. Now, I guess our current government is of the view that doesn't really support that outcome doesn't really support our gig economy, doesn't support where employers are heading, and they also recognised that there is a little bit of confused case law on this issue. So what the legislation does is it creates a hard and fast test to determine whether or not someone is a contractor or an employee.
Nice. And so in that new legislative change, what's new, what was removed, or what's been modified?
Yeah, okay. So I guess if we touch on the test itself, there's no grey. It's pretty black and white. So for someone to be a contractor, number one, they have to have an agreement that says that they are a contractor or not an employee. Secondly, the worker can't be restricted from working for other people or other organisations. Number three, the worker is either not required to work or be available to work at certain times, days, or for a minimum period, or they must have the ability to be able to subcontract the work. the fourth aspect is a business can't terminate because a worker turns down a piece of work, and the worker has had reasonable opportunity to seek advice on their independent contractor agreement. So what we have now is a pretty hard and fast test as to whether or not someone is a contractor or an employee.
And so what's the timing or like the transitional rules for this change coming into effect?
Yeah, so this took off as soon as the legislation came into place. So 21 February, this hit the ground running. What's a little bit confusing about this, and there is actually there's contradictory, I guess, commentary on this issue out there. And I think if anyone who's listening goes, Fiona, I still don't understand that, feel free to give me a buzz, because I feel like it's a work in progress from my end to explain this properly. But essentially what the position is it applies to all arrangements, whether they were entered into before 21 February when the legislation came into place or after 21 February, right? So it applies to every contractor agreement.
Right.
The only carve out to that is if there was an agreement in place before 21 February, and it's found that you are a contractor, that will actually only apply from 21 February unless there were already proceedings within the authority or court. So actually, Lucy, who's a solicitor in my team, she has nailed the explanation of this. She always talks about how it's retrospective, but it's not retroactive. So yes, we look in historically, but it doesn't kick off until the 21st of February.
All right. Thanks very much, Fee. Let's move into our second change then, shall we? Should we go with the 180 to 200K employee?
Yeah, perfect.
All right, cool. So key provisions around this change?
Yeah, so I guess at a very high level, this change is simply that employees who earn over 200,000 won't be able to raise a personal grievance for unjustified dismissal moving forward. I think the key there is that they just won't be able to raise a claim for unjustified dismissal. They'll still be able to bring other claims, so disadvantage claims, breach of contract claims, but they specifically can't raise a grievance for the termination or the end of the employment relationship. So that's it in a nutshell.
Yeah. Okay. So before that, what was happening?
Well, the reality is anyone could raise a personal grievance. What I would probably just add to that, though, is, big generalisation, but sometimes employers, when they had an employee who earned over 200K and wanted them to move on, often a formal employment process wasn't followed. There were, I guess, what we often call fireside chats or exit discussions, i.e., look, this isn't working for us. It probably isn't working for you. Let's reach an agreement. Now, the bonus of that for an employer is it just meant that they didn't have to go through some arduous process. But now that essentially an employer doesn't have to go through an arduous process to get rid of someone who earns over 200K, I think you have to wonder now whether or not those exit discussions or fireside chats will happen. In my practice, they are still happening because this is pretty new legislation and people are a little bit nervous about it, I guess. But it's one of those things I think time will tell.
Yeah. And speaking of time, is this one in the same effect for 21 Feb that you just mentioned with the other ones?
So essentially the position is any new employment agreement entered into after 21 February where the employee earns over 200K, this will automatically apply if the employment agreement allows for it or doesn't contract out of it. For people who were earning 200K at 21 February, they've got a transition period of a year to negotiate with their employer as to how they want this to be treated. So we're seeing this, I guess, come about in various ways. employees earning over 200K are going to their employer and saying, hey, look, I know this new law is going to apply to me at 21 February 2027. Can I be carved out of that? Can there be an exception for me? Or, hey, can there be a longer notice period if I do get terminated? So essentially, if you are acting for someone, they are on 200K as at 21 February, you've got till 21 Feb next year to essentially negotiate for something that isn't the law.
At Chisholm Clark, I spend a lot of time talking with lawyers about their careers. Sometimes it's because they're unhappy, sometimes they're just curious. Sometimes it's because they're well and truly ready for a change. And look, if you genuinely love your job, if you have that rare mix of great work and colleagues and great balance, then that's fantastic. Honestly, you don't need me. Just keep on going. But if you're wondering if this role, this firm, this area of law is really for you, then that's where we can help. Chisholm Clark is a legal search firm built just for lawyers here in New Zealand, where we listen, get where you're coming from, and help explore what your next chapter might look like, both confidentially and without any pressure on time or preferred clients. Because a legal career should feel sustainable, not overwhelming, sometimes the best way to protect your well-being is by simply finding the right fit. Your future in law doesn't have to feel heavy. It might just need a new chapter. So if you're ready to chat or just want to know your options, head to chisholmclark.co.nz or reach out today for a confidential, sensible chat with no pressure. All right, let's move on to our next change. Let's touch on the 30-day rule.
Yeah, okay. So, look, I don't think this is going to be a huge part of people's practices, but it is one of those bread and butter things that you have to know. So on the off chance that someone who doesn't do a lot of employment law is listening, the previous position was that if an employee started at a new workplace, and this was a workplace where there was a collective agreement in place, the employee had to be on the terms of the collective or terms that were similar to the collective for the first 30 days. And then at day 30, the individual could decide whether or not they want to stay on the collective agreement and pay union fees or whether or not they wanted to move to an individual employment agreement. So that was the position pre this.
Beforehand, yep.
What we have now post 21 February is if an employee starts with an employer and there is a collective in place from day one, an employee can decide, yes, I want to be a member of the union and a party to the collective, or I want to be on this individual employment agreement where I negotiate my own terms and conditions. So for those who are listening who've been practicing for a long time, this rule has ping-ponged quite a bit. Whenever there's a bit of a change of government, this is quite an easy one to flick the switch on. But as we talk right now, an employee can be on either agreement from day one.
Okay. Is there any benefit to being on one more than the other, or?
Look, I guess the answer to that depends a little bit on your political views. So gross generalisation, but I guess our left parties in government are very pro-union, are very supportive of unions, and they want to increase union membership. So this was one way to do that. I guess, though, if we talk about pros and cons, probably the only thing that I think employers need to turn their mind to, and sorry, Sam, once again, apologies if I lose the people who are listening, but essentially under the old law, an employer couldn't really have a 90-day trial period. Now, what I mean by that is a collective agreement never has a 90-day trial period. You're never going to get a union to agree that their members will be subject to a 90-day trial period. But as a result of that, because someone had to be on the similar terms and conditions to the collective for the first 30 days, that workplace could never have a trial period, because even if someone moved to the IEA at day 31, you can't insert a trial period then because they've already worked for you for 30 days. Now, I guess there's a bit of excitement amongst employers on this issue that, yay, we can finally have 90-day trial periods in our individual employment agreements. Yes, you can. Yes, that's correct. But I think what people listening to this podcast need to think about and need to have a chat with their employer clients about is strategically, if you do that, you potentially run the risk of more employees joining the union and being a party to the collective, right? Because if you're a Joe Blogg's employee, day one, you get an agreement that one has a collective and one doesn't, right? One has a 90-day trial period and one doesn't. Probably natural instinct is to sign the one without the trial period, right? You want that job security. So, look, I'm not going to make any views about whether or not union membership is a good thing or a bad thing. But what I do want to say is if your employer clients don't want to drive up union membership, they need to have a really good think about whether or not they shove those 90-day trial period clauses in their IEA. Does that kind of make sense?
Yep, totally. Thank you.
Yeah.
Now, the same timing on this as the previous changes were already in effect, or is there something still to come?
Yeah. Already in effect. And I guess probably the only thing I would add to that is before you advise your employer clients of this change, you do have to just double check the collective, because you might actually have a clause in the collective that says it doesn't matter what the law is. People will be on the terms and conditions of the collective for the first 30 days. So if you've agreed with that with the union, you're kind of stuck with that no matter what's in this legislation. So yes, it's at play, but I think before you advise your employer clients, you do actually want to double check what their collective actually says on this issue.
Yep, great. All right. And our last change then, we had some changes to the personal grievance remedies.
Yeah.
So, first question for you on this bit is, what are the key provisions here?
Yeah, so once again, I think this is probably a good one where we talk about what the law was to fully understand what the law is now. So essentially what the law was previously is the authority or the court could say, right, Sam, you were unjustifiably dismissed, and we're awarding you $30,000. But because you contributed to that situation, we're actually going to take away $10,000 from you, right? So the courts could always look at an employee's contribution to the personal grievance arising. What the change now is, it's a little bit more hard and fast, and there's probably less discretion for the authority or the court on this issue. And look, apologies, I am going to just read this bit because it is a little bit wordy and it is a bit hard it's a bit easy to muck up. But essentially, what the change is now is no remedies can be awarded by the authority where the employee's actions contributed to the situation arising, and they constitute serious misconduct. So essentially what that's covering is Sam, if you steal $20,000 from your employer, the employer runs no process to terminate you. They just go, Sam, you're fired, and you take it to the Employment Relations Authority. Under this legislation, what it means is, well, Sam, we're going to award you $30,000 because they didn't fire you properly, but actually because you stole from them, we're taking $30,000 off you, so you get in zero. Yep. Okay?
Yeah.
So it's a bit more hard and fast. The other part of it is if the employee has contributed to the situation that gave rise to the personal grievance, the authority must not provide for reinstatement. So Sam, if you nick 30K, there's no process, you apply to the authority for reinstatement. The authority's going to say, no, you stole from your employer, you're not getting your job back. Mm-hmm. And as I said, there's no compensation for hurt or humiliation, but you could potentially get lost wages, Sam, right? Mm-hmm. And I guess as an extension of that, remedies can now be reduced by 100%. So what we were seeing in the authority is, I guess, reductions of 10%, 20% for an employee's contribution to the situation. Now they could lose the lot.
The whole lot, yeah.
Yeah.
Okay. And same thing, like this is already in effect, or is there anything still to come?
So this applies to terminations following 21 February. So if you are acting for an individual, they lost their job post 21 February, this law applies if you're acting for them raising a grievance.
Okay, cool. All right. Well, thank you very much, Fee. I think that certainly covers the 4 areas of change that are largely largely taken up by this legislative change. Let's delve a little bit more now into the practical implication of this, like what it actually means for, the impact on our lawyers. Do you think you could start by breaking down day-to-day implications for our practicing lawyers at various levels?
So I think probably if I look at it, I think probably the two main changes where I guess as a team we're having to focus a little bit more on and actually turn our mind to. The first is around this contractor or employee issue. So I know that Joseph, who's a special counsel on my team, he's in the background making sure that our independent contractor agreement, the precedent that we provide to our clients, is compliant with the gateway test, so that if one of our clients has got one of our agreements, they can be satisfied that the agreement complies with the gateway test. And then all going to plan, they won't have to worry about arguing about it in court one day. What I will add to that, I guess, is we lose control, I guess, about how our clients apply that agreement and actually what happens in practice. So I think when we are providing our clients with these contractor agreements, we've got to be saying to them, well, hey, this is what the agreement says, but you've got to make sure that you actually stick to these arrangements. Because, for example, if you all of a sudden start requiring this contractor to be there at 9 a.m. on Monday for the team meeting, well, you're going to fall over on the gateway test. So I think it's not just a case of giving our clients the agreement and saying, way you go. I really think we've got to talk them through what the day-to-day relationship with the contractor needs to be compliant with this gateway test. And I think probably the second thing we are spending a lot of time on is it's really this issue around the change in remedies is really affecting the strategy for us when we are defending personal grievances on behalf of employers and we're acting for individuals raising personal grievances, because we've really got to turn our mind to, well, look, we can't just rely on all these process issues, because we're just going to get a response back from the employer's lawyer that says, yeah, my client did muck up all the process, but Fiona, your client stole $30,000. So if you take it the whole way, they're not going to get anything anyway. So I think as employment lawyers, we've got into the habit of, when raising a personal grievance for unjustified dismissal, we're going, dear employer, these are all the process issues you mucked up. These are all the things that make the behaviour not that bad. Therefore, the termination was unjustified. I think there is going to have to be a bit more of a focus now on what Joe Bloggs actually did, and us showing to the employer, well, actually, this doesn't amount to serious misconduct. They didn't contribute to this, so you're in a little bit of trouble if we end up in the authority. So I guess, Sam, to answer your question from a practical perspective, out of the 4 changes, we're finding those are probably the 2 things we're working on the most.
Cool. Okay, look, we're into summary mode now, Fee. We've obviously covered, again, some really good ground. So to summarize this episode for our listeners, could you please take us back through and recap what the main legislative changes are for this round, and what they mean for our lawyers and why they should care?
Yeah, okay. So I guess by way of summary, we now have our Employment Relations Amendment Act, which has made 4 key changes. The first is, when determining whether or not someone is a contractor or employee, we've got a hard and fast gateway test to determine whether or not someone is a contractor or an employee. As I've said a couple of times, just because someone fails at that hurdle doesn't mean it's the nail in the coffin. There is still the argument that they could be a contractor. I just think it would make it a lot harder. The second key change is employees who earn over 200k won't be able to raise a personal grievance for unjustified dismissal moving forward. They'll be able to raise a number of other claims, but just not a claim in relation to their termination. We've had a flip-flop of the 30-day rule, so employees can now decide from day one whether or not they want to be a party to a collective or sign an individual employment agreement. And last but not least, if you are in the Employment Relations Authority acting for an individual who's had their employment terminated for serious misconduct, even if the employer has mucked up the process, if the authority is of the view that your client has committed an act of serious misconduct, they may end up with little to no remedies. So that's it in a nutshell.
Well, that's a good place to leave it there, Fee. A big thank you to our guest for sharing her time, experience, and insights with us today, and to our audience for listening. We hope this conversation has given you something valuable to reflect on and apply in your own journey. If you found this interesting, please leave us a comment or a rating in the podcast app so we can reach more curious minds like yours. I'm your host, Sam Lindsay from Chisholm Clark, and we'll see you again soon on the What a Lawyer podcast.